He didn't think he was signing away his rights. He thought he was offering me a gift. I was 31 years old, 8 weeks pregnant, and sitting across from a man whose net worth had been estimated at somewhere north of $400 million. He had a yellow legal pad in front of him. He had a pen. He slid a number across the table. Not a check, not a contract, just a number written in neat block letters, and he said very calmly, "This is enough to start over anywhere you want." I looked at the number. I looked at him. Then I folded the paper in half, put it in my purse, and said I needed to use the restroom. I didn't come back. Let me back up, because I know how this sounds. I know what you're thinking. How does a 31-year-old end up pregnant and sitting across from a billionaire who wants to pay her to disappear? And honestly, if you'd told me 2 years ago that this was where my life was headed, I would have laughed. I was the responsible one. I was the one who had a 5-year plan written out in a notebook. I was the one who did things the right way. I grew up in Raleigh, North Carolina, second of 3 kids, middle daughter in a family where nobody had a lot, but everybody had enough. My dad worked for the county. My mom taught 3rd grade for 26 years. We had dinner at the table every night, went to church most Sundays, and I understood from a young age that you built a life the same way you built anything else. Slowly, carefully, one brick at a time. I moved to Charlotte at 25 for a job in healthcare administration. Nothing glamorous. I worked for a regional hospital network managing contracts with insurance companies, and I was good at it. I was very good at it. By the time I turned 29, I had a corner office with a view of the parking deck and a savings account that I was genuinely proud of. That's when I met him. His name isn't important. I'll just call him what he was, my ex. He was 44, recently separated, and he came through our hospital network as part of a consulting engagement. His family owned a private equity firm out of Raleigh, the kind of firm that had fingers in healthcare, logistics, real estate. The kind of family that had a wing named after them at a university. Nobody could quite remember which one. He was smart. He was funny, actually, in a dry, self-deprecating way that surprised me. He made me feel like the most capable person in the room, which, looking back, should have told me something about who he needed me to be for him rather than who I actually was. We dated for about a year, quietly. He wasn't divorced yet, and I told myself that was fine, that things were complicated, that I understood. I did understand. I understood more than I should have let myself understand. Then I got pregnant. I found out on a Tuesday morning in March. I was alone in my apartment bathroom, and I sat on the edge of the tub for a long time before I did anything else. I'm not going to tell you I wasn't scared. I was, but underneath the fear there was something else, something I didn't expect, and it took me a while to name it, relief. Not because I'd been trying, I hadn't, but somewhere in the back of my mind I had spent the last year watching this relationship become something I didn't have words for, and the pregnancy made everything suddenly terribly clear. I knew what I wanted. I wanted to keep this baby, and I knew, sitting on the edge of that tub, that wanting that was going to cost me something. I told him that evening. I drove to his condo. He'd moved out of the family home by then, and I sat across from him at his kitchen island and I said the words. His face did something complicated. He was quiet for a long time. "I need some time," he said. I gave him 2 weeks. At the end of those 2 weeks, I got a phone call from a number I didn't recognize. It was a woman. She introduced herself as his mother's personal assistant, and she asked if I would be willing to meet with the family. I should have known then. I should have recognized exactly what that phone call was. But I told myself it was a good sign. I told myself they wanted to be involved. The meeting was at a restaurant in South Park, the kind of place with white tablecloths and a wine list longer than most people's mortgages. His father was there, his mother, and a man I later learned was their family attorney, though nobody introduced him as such. My ex sat at the end of the table and did not look at me once. His father did most of the talking. He was 71 years old, trim, silver-haired, with the particular confidence of a man who had not been told no in several decades. He called me by my first name immediately, not unkindly, but in a way that established something. He said he appreciated me coming. He said the family had discussed the situation and wanted to help me. That was the word he used, situation. He said they understood this was a difficult time. He said they wanted to make sure I was taken care of. He said, and here he paused, just slightly, the way a man pauses when he's delivering language he's been coached on, that they hoped we could handle things privately and amicably in a way that allowed everyone to move forward. Then he slid the yellow legal pad across the table. The number was $3 million. I sat there. I looked at it. His mother was watching me with an expression that I can only describe as professional sympathy, the look of a woman who has managed difficult situations before and fully expected to manage this one. The family attorney studied his water glass. My ex looked at his hands, and I thought about the baby. I was 10 weeks along by then. I had already heard the heartbeat. I had already started taking a prenatal vitamin every morning with my coffee, a small ritual that had made me feel, for the first time in a long time, like I was building something real. I thought about all of that, and then I picked up the legal pad, turned it over, and said, I appreciate your time. I didn't use the restroom this time. I just walked out. I'm not going to pretend I wasn't shaking when I got to my car. I sat in the parking garage for 20 minutes. I called my sister. She's the only person outside of this story I want to mention by name, so I'll just say she's 5 years older than me and has always been the person I call when I don't know what to do, and I told her what happened. She was quiet for a moment. Then she said, So what are you going to do? I said, I think I need a lawyer. She said, Good. I want to talk about the lawyer I found because she matters to this story in a way that's hard to overstate. Her name is, well, I'll call her my attorney. She ran a family law practice in Charlotte, and she'd been doing it for 22 years. She was straightforward in a way that could feel abrupt if you weren't ready for it. At our first meeting, she sat across from me with a yellow legal pad of her own. I've thought about that symmetry many times since, and asked me to tell her everything. I told her everything. When I finished, she didn't say anything for a moment. Then she said, Have you signed anything? I said, No. She said, Good. Don't. She explained the situation to me in plain terms. In North Carolina, child support is determined by the North Carolina Child Support Guidelines. It's a formula based on both parents' incomes, custody arrangement, and certain extraordinary expenses. For high-income cases, the court has discretion to deviate above the guideline amounts when the formula doesn't adequately meet the child's reasonable needs. She said that, given the father's documented income and assets, we would be filing for a deviation. She also said something I hadn't considered. She said that establishing paternity now, before the baby was born, was possible and might be strategically important. In North Carolina, prenatal paternity testing can be done through a non-invasive process, a blood draw from me and a cheek swab from the alleged father, as early as 7 weeks. It's admissible in court. She said we should get that process moving before anyone on the other side had time to complicate things. I asked her what she meant by complicate things. She gave me a look that I understood immediately. I called my OB the next morning. My ex did not respond well to the paternity testing request. I learned this not from him directly. He had by this point stopped contacting me personally, but from a letter I received from his family's attorney, a firm out of Raleigh that I recognized from local news coverage of various corporate matters. The letter was 3 pages long and said a great deal of things in very careful language that essentially amounted to, We would prefer you reconsider your current approach. My attorney read the letter, set it down, and said, Good, they're nervous. I asked if that was a good thing. She said, It's always a good thing. We filed the paternity action in Mecklenburg County Family Court. My attorney filed simultaneously for child support, requesting a deviation from the standard guidelines based on the father's financial capacity. She attached documentation, articles about the family's business holdings, publicly filed tax records for the firm, a recent profile from a Charlotte business magazine that had estimated the family's real estate portfolio alone at somewhere near $200 million. The family's attorneys filed a motion to delay the paternity testing, citing concerns about the procedure's necessity. The court denied it. I want to tell you what those months were like because it wasn't all legal strategy and courtroom drama. It was mostly just me, alone in my apartment, working from home 3 days a week, growing a person inside my body while simultaneously navigating a legal process I had never imagined. I was tired in a way I had never been tired before. I was sick most mornings until about week 14. I had a body pillow I'd named after a television character, and a white noise machine I couldn't sleep without. I ate a lot of cereal. I watched a lot of nature documentaries. I talked to my baby the way my mother had told me she'd talk to me, just narrating the day, saying what I was doing, introducing her to the world before she was in it. Because by week 20, I knew she was a girl. I cried in the ultrasound room, which I had not expected. The technician handed me a tissue without making a big deal of it, which I appreciated. I drove home, sat on my couch, and thought about what I wanted for her. Not just the money, though the money mattered, and I want to be clear about that, because nobody should pretend it doesn't. Single-parent households in this country carry a financial burden that is not abstract. It is groceries and childcare and health insurance and all the things that quietly compound over years into exhaustion. But more than the money, I thought about what I wanted her to understand someday, about how her mother had been offered the easy way out twice, and both times had chosen the harder thing instead. The paternity test came back in early August, positive, as I had always known it would be. His family's attorneys pivoted immediately. The new position, delivered in another very careful letter, was that the father acknowledged paternity, wished to be supportive, and proposed a private financial arrangement that would, in their language, address the child's needs comprehensively without the disruption of ongoing litigation. They attached a proposed settlement. It was, I'll admit, a large number, larger than the first number, larger than the second. I sent it to my attorney. She called me that evening. She said, "Do you understand what you're giving up if you sign this?" I said I did. She said, "You're giving up the ability to return to court if circumstances change. You're giving up the court's ongoing oversight. You're giving up any ability to modify support upward if his income grows, which, based on everything I've seen, it will." I asked her what she recommended. She said, "Don't sign it." I said, "Okay." There was a pause on the line, and then she said something I've thought about many times since. She said, "You know, most people take the money, not because they're wrong to, sometimes it's the right call. But the people who don't take it, the ones who go through the whole process, they almost always say it wasn't really about the money by the end." I asked her what it was about. She said, "Recognition." The court date was in November. My daughter was born in October, so she was 3 weeks old when the first hearing happened. I left her with my mother, who had driven up from Raleigh and was staying in my second bedroom in a level of domestic mobilization that only mothers are capable of. She had reorganized my entire kitchen while I was in the hospital. I chose not to mention it. I sat in a family court in Charlotte wearing a blazer I'd had to have let out at the seams, and I listened to my attorney argue our case. The other side's attorneys were good. I want to be fair about that. They had done everything right procedurally, and they came in with a clear strategy. The father's liquid assets were substantially tied up in the family business, and the business distributions were variable, and therefore a deviation from the guidelines would be speculative and inappropriate. My attorney countered with documentation of the family's lifestyle expenditures. Property tax records, a documented vacation property in the Outer Banks, vehicle registrations, membership records from a private club in Raleigh that charged initiation fees north of $50,000. She said, and I remember this clearly because she delivered it so quietly, "The court is not being asked to speculate about this family's financial capacity. The court is being asked to look at the evidence of what this family does with its money and to ask whether that child deserves any portion of it." She gestured toward the seat where I was sitting. The other side's lead attorney said something about the complexity of privately held business structures. The judge said, "I'm familiar with the complexity. I'm not going to give you the full number because the final order is sealed and I want to keep it that way. What I will tell you is this. It was more than the guidelines, significantly more. It included a monthly support figure, a provision for private school tuition once she reached kindergarten age, a health insurance premium rider, and a semi-annual review clause tied to a percentage of verified business distributions. It also included a provision I had asked my attorney to add specifically, and which had caused the most argument, a requirement that her father appear in court, in person, to acknowledge the order. He did. He sat across a courtroom from me for the first time since the restaurant in South Park. He looked the way people look when they've spent 6 months being managed by attorneys and have finally run out of procedural options. Tired, and a little diminished and oddly young, in the way that powerful people sometimes look young when things don't go their way. He did not look at me. The judge read the order aloud. My attorney sat beside me and made a note on her legal pad. And I thought about my daughter at home with my mother, probably asleep in the bassinet we'd assembled together the week before I went into labor, in the second bedroom of my apartment that I'd painted a soft yellow because I'd read that yellow was good for infant brain development, and I'd decided to take no chances. I thought about her, and I didn't feel triumphant. I felt something quieter than that. Something that had taken me about 9 months to understand was the correct response to all of this. I felt clear. She's 8 months old now. She has my nose, and I'll say it, even though it costs me something. Her father's eyes, this particular shade of gray that goes darker when she's thinking hard about something, which is constantly, because she is already the most curious person I have ever met. We're not in the same city as his family. I want to be honest that the distance is intentional. He has the ability to request parenting time through the court. And the court has its processes, and I cooperate with those processes because that's what the order says, and also because I genuinely believe she deserves to know where she comes from. Both halves of it, even the complicated half. But I want to say something about the offer. About both offers, actually. The first one at the restaurant and the second one in that settlement letter. People ask me sometimes, friends, my sister, women I've met in prenatal yoga or in the waiting room at our pediatrician's office, they ask me if I regret not taking the money, the lump sum, the clean break. And I always say the same thing, it was never about the money. The money was what they were offering me instead of recognition. It was a substitution. Here, take this, and in exchange, agree that you don't matter enough to make a claim. Agree that this child is an inconvenience that can be resolved with a large enough number on a yellow legal pad. I don't blame the money for existing. Large amounts of money exist, and people use them to solve problems, and that is the world. But I was not a problem to be solved, and she was not a problem to be solved. She was a person. She is a person. And she deserved to enter the world with her personhood already established, not just in my heart, but in a court of law with a judge's signature and an order that can't be folded in half and put in someone's purse. There's a detail I've thought about a lot since all of this ended. When his father slid that legal pad across the table at the restaurant, when he wrote that first number, he wrote it in pen, not pencil. Pen, the way you write something you're confident in. The way you write something you expect to be accepted. My attorney used a legal pad too, yellow, same as his, but she wrote in pencil, the way lawyers do, because everything is subject to revision, because documents are living things and you don't commit to ink until you know what you're dealing with. The final court order was printed on official paper and signed by a judge and filed with the Mecklenburg County Clerk of Courts. It is not written in pencil. It is not subject to revision unless I petition the court. It exists in a way that a number on a legal pad does not exist, in a way that a lump sum negotiated over a restaurant table does not exist. I have a copy in a file folder in my closet. I have another copy in my email. I have another copy saved in 2 different cloud accounts because I am, as I've mentioned, the responsible one. And every morning when I get up and go in to get her out of her crib, she sleeps on her back with her arms over her head, which I've read is how babies sleep when they feel safe. I think about that file folder, not in a triumphant way, just in a quiet way. We're here, we're documented, we're not going anywhere. That's not revenge. That's not even victory, exactly. It's something I think I'm still finding language for. But if I had to name it tonight, sitting in the middle of a story that's still unfolding. I would say it's something close to this. Protection is not the same as hostility. Fighting for what's yours is not the same as taking something away from someone else. And knowing the difference, really knowing it, in your body, in the room where you say things, and the room where a judge reads things aloud, that's what nobody can offer you on a legal pad, no matter how large the number is. She woke up about an hour ago and I fed her and she went back down. The apartment is quiet. The white noise machine is on. The soft yellow walls of her room are the last thing I see when I turn off her light. I didn't start over. I didn't go anywhere. I was already home.